वीडियो ऑन करो, वीडियो ऑन करो।
वक्रतुंड महाकाय सूर्यकोटे समप्रभ निर्विघ्नं कुरु मे देव सर्वकार्येषु सर्वदा। वक्रतुंड महाकाय सूर्यकोटे समप्रभ निर्विघ्नं कुरु मे देव सर्वकार्येषु सर्वदा।
Good morning. Namaskar. And welcome everybody today in this GIPC seminar on the topic Universal Access to COVID-19 Pandemic Related Vaccines in the TRIPS Agreement. We all know that the whole world has been passing through a very deep health pandemic, and two severe phases or two severe waves of COVID crisis have been overcome by the people around the world in a very bold and in a very rational manner. And we have seen both the economic pandemic and the health pandemic. And during this COVID era, officially being announced from 25th March 2020, Global IP Convention has organized 3 seminars during this COVID period, and this is the 4th one. In the first seminar, we had more than 100 participants, and that was primarily focused on the COVID issue. And the second was also focused on the COVID, and the third one was on the artificial intelligence and several other IP related issues. Today's seminar is divided into 3 sessions. The first session is on the COVID related pandemic issues and what kind of medicines are available, what are the efforts for universal access to the vaccines and the medicines, and what are the provisions of the TRIPS, as well as what are the enabling provisions in the Indian Patent Act about the compulsory licensing and other issues. The second program technical session is on environmental issues, because that is also becoming a very major issue these days, particularly after the recent IPCC report, the intergovernmental panel on the climate change that was on the 9th August, and which has also given very, very serious warnings about what the world could be by 2040 if there is no control on the greenhouse gases and on the carbon emission. So we know that the world community under the leadership of United Nations framework on the Convention for Climate Change, the first Earth Summit took place in Stockholm in 1972, then in Rio de Janeiro in 1992, and thereafter in Kyoto in 2005, and thereafter the final legal framework was drawn in Paris in 2015, and thereafter the conference on the regular conferences are being organized, and the 26th COP, the conference of the parties who are involved with this, I mean the nations. So 192 nations will be participating in the Glasgow conference, which is going to be held beginning 30th October until 12th November. And hopefully the nations would be following the determination which they have issued the national commitments for each country. And otherwise, the warnings as severe as that if we don't follow this, then maybe by 2040 or 2050, the sea levels may go up by more than a feet, and countries like Bangladesh may be fully under the water. And similarly, in our country also, the certain coastal areas may be swept away in the water. So environmental science is also coming up, and we have to understand the implications and various kinds of technology which are coming up, and for the green energy and the green technology. So that is the second one. And the third one is on the ICP, that is special essential patents and the FANT. And that we know is more relevant for the telecom and automobiles. And we had one full seminar on this topic in Chennai in 2020. In 2019, December. So GIPC is in its continuous effort for updating our patrons and our well-wishers, and I hope today's discussion deliberations, and I welcome today's speaker, Mr. Calab Gabriel, who is the Managing Director, Lex IP Care. He will be the first speaker. Then we welcome Mr. Sudarshan Bansal, a long friend of mine. I am able to see his face, and I request all other members if they can put on their videos. Dr. BK Sahu from NRDC.
Good morning, sir.
Yeah, good morning. And then Mrs. Renu Bala, I am able to see her also. Good morning, ma'am.
Morning, sir.
Sudarshan Sahu, good morning. I'm just unable to see the face of Calab. I think he's yet to join, so doesn't matter. And then something I would say about this universal access to vaccines and medicines. As we all know that the first proposal for this patent-free vaccine came from India and South Africa, which had passed one resolution on 16th October 2020. And thereafter, both India and South Africa, and then along with several other countries, they passed a resolution. And on the 21st May 2021, and similarly, some revised proposals have been sent to the various countries. And now there is a consensus on this, and I think under a lot of pressure, various countries, they gave their consent. I mean, earlier, President Biden was not giving his consent about this patent-free vaccine, but gradually, slowly, most of the countries have agreed, and thereafter, the proposal went to the General Council, the TRIPS Council, and the matter was discussed thoroughly on the 8th and 9th of June 2021. But basically, we first started that since this is a public health issue, and as per Doha Declaration also, on all these public health issues where there's a pandemic, the member countries should allow under the WTO consensus as per the Doha, para 4 and 5. And the TRIPS Council has in principle agreed about this, but initially we thought of only making this technology for the vaccine free from patent, but later on India and several other countries, they found that only making the patent free will not help, because there are several other connecting issues. So therefore, under Articles 7 and 8 of the TRIPS, it was proposed that not only should the patent be made free, but also there should be relaxed view about the technology transfer, because once you allow only the patent, the infringement provisions to be relaxed, but then unless the technology is transferred, because medicines and vaccines both are different. Vaccinations is a biological issue, so where the technology is very important, as against the medicines where you only have the formula and you can do some reverse engineering and do it. But in case of the vaccinations, you also need the technology. So the members also then added the issue about the technology transfer. And the third issue, which was also proposed in the WTO TRIPS Council, that even if the patent is made free, the technology is given, but the country where they would be manufactured, they may not have the sufficient and the enough raw material. So the countries who have the raw material to manufacture the vaccinations may not incline to supply adequate quantity. So therefore, a very holistic approach was taken, saying that number one, the patent should be made free. Number two, the technology transfer should be allowed. And number three, the related raw materials should also be supplied. There could be some other issues which I think the experts can deliberate and discuss. But the whole issue is that this is a humanistic issue, and therefore there should be liberal approach, because we know that the world has a population of 785 crore people. In India itself, we have 135 crore people. And then earlier it was thought that only adults should be vaccinated, and thereafter now we feel with the different kind of variants, the alpha variant, beta, and then the delta variant and whatnot. So even the children are subject to that. So if the conventional method of 2 doses, if not the further booster, then also for 785 crore people, we know we need about 1,500 crore doses for the entire global community. And for India, initially we thought that only 90 crore people would be required to vaccinate, so about 200 crore doses of vaccines. And Government of India, through our domestic 2 companies like the Serum Institute, which was licensed by AstraZeneca, and AstraZeneca in turn got the technology from Oxford University, because initially it was invented by this Covishield. And then in India, we had our Bharat Biotech, which came out with Covaxin, and now Covaxin has been licensed to several PSUs and other companies. And now we have Sputnik in India from Russia, and Dr. Reddy is licensed to manufacture it. And thereafter, Cadila, Zydus, and several companies have come out. And now, by now, although the figures for this COVID are very, very, serious figures, we have so far in the world level, 23.31 crore people have been affected by COVID, and 47.47 lakh people have died. And as far as the vaccination is concerned, throughout the world, 592.25 crores have been people have been vaccinated, at least one dose. And in India, we had 3.37 crore people who got infected by COVID, and in India there were deaths of 4.47 lakh people. So it's a huge figure. If worldwide 47.47, in India 4.47 lakh people, and then in India so far we have been able to vaccinate around 80 crore people, at least a single dose. But the whole issue is very serious, and I think that we have to, be very careful about this vaccinations and other things. So the whole issue is how to, take care about this vaccination problem and the issue relating to availability of this vaccine. So therefore, I think that members can do further deliberation about it, and what is the way out, because as per the the WTO TRIPS Council, the decision which has been taken in principle, the WTO TRIPS body has agreed in principle during their last meeting on 8th and 9th of June. But thereafter, as per the WTO provisions, as we know that in WTO there is an agreement establishing WTO, which says that if the TRIPS Council agree, and if the General Council also agree, then the Ministerial Conference is the highest decision-making body. So that WTO conference is taking place on the 30th November until 3rd December in Geneva. So I think that the Ministerial Council will take a final decision, because the TRIPS Council can only agree in principle, but it is the Ministerial Conference which is the ultimate decision-making body in the WTO. So once this is done, then only I think the final concurrence about the mandatory provisions about accessibility, but maybe the issue which was so relevant during the month of May, when the second wave was going on, and by now, when we have already been able to vaccinate about 600 crore people out of say nearly 800 crore people, but still the issue remains live, because there are several countries in Africa and Latin America who do not have the manufacturing facility, and therefore even there's a lot of difference at in the cost. The vaccine which costs about minimum $10 in the United States, it costs nearly 700 to 800 rupees only, or 7,000 rupees in India. So even that is an issue which has to be considered, because the vaccine, once it is made patent free, then I think the prices can go down, both for the medicines and the vaccine. So this is a very important health issue. So GIPC thought that let this be discussed and deliberated through the expert panel. So now I request, without taking much of your time, to our very learned first speaker, Calab, who happens to be my very good friend, and he had been in our earlier first conference also, and I am very hopeful that we all will be benefited through his television. So Calab, welcome to you and good morning. And
good morning, Dhanpat. So nice to see you.
I request you now to please start your television.
Yeah, I have a few slides to flash.
Okay. So my technical team will help you. Rajat, over to Rajat. Rajat will help you. Yeah.
All right.
Yeah.
So thank you, and thanks. It's a wonderful introduction. Of course, it's my honor, my pleasure to be in the conference, and especially with you. The first slide. Can you go to the first slide? Yeah. Just there, Priya. Just the first slide. We are talking about the title is Vaccine and TRIPS. But we should know, just in prelude for my introductory talk, vaccine, what is the vaccine is prophylactic, increases the antibodies. That is the thing. Drugs are curative. Mostly we think of drugs that are curative in nature, but vaccines are prophylactic, is preventive. It's a thing. And no, prevention is better than cure. And that's the reason that, and it's been administered in mass scale. It's not a selective drug administered to the individual, like I am a arthritis patient, I take a particular drug. But vaccines are mass production, mass administration, including the children. Like when a newborn baby, they just put the vaccine and they send it home. So this is an important thing. And it's been approved by almost, yes, DCGI and then also FDA permission. But the stringent, very, very stringent approval processes for vaccine, much more than the other drugs, other kinds of drugs. Of course, vaccine is a drug. It's been classified under drugs, but compared with the other kind of drugs, like the curative drugs, the tests for vaccine and approvals are extremely stringent. That's a thing, because it is not only administered large scale, but also administered repeatedly. Now, every time, like now for COVID-19, we have to have 2 shots. We do not know, there might be another program where we have to take 1 more shot or something like that. So it has been given repeatedly, and it's given to the healthy patients and not to the sick patients. And that is what the important thing. And the other issue, just I want to flag it, that just mere vaccine is not going to address the pandemic. It is the holistic approach, because the vaccine is one component of the pandemic. Of course, it's an important component, but other things like preventive, should come out with really antiviral drugs. You need to have facilities to manufacture. You have to have finances. You have trans-border free flow of the materials and substances. So many aspects, which ought to be a holistic approach. The next slide. These are, of course, this pandemic has affected whole world. I mean, no demarcation between rich and the poor and the west and the east or south. There's no, and it's affected. But the people who are really affected are the people from the developing and the least developed countries, because of all the things. And most importantly, the last one, there's no sustainable development goals, especially in the developing and the least developing countries. That is one of the aspects which we need to address it immediately and in long term. These are the things. Of course, other things, we all know that there are other issues. Next slide, please. And as Tanpat mentioned, that there are negotiations and discussions. And eventually, TRIPS alone cannot solve the issue. Of course, TRIPS gives the IP aspect of the issue. Because TRIPS is restricted to intellectual property and related issues. But it ought to be thrashed out at WTO level, because WTO is the organization which controls the trade across the members. And it ought to be worked out at WTO. Unfortunately, WTO, based on the recommendation for TRIPS, has recognized the importance and how it ought to be managed and administered. In 2nd October, 1 year back, 2020, WTO has come out with this strong recommendation. And also it has put into a place these recommendations. What are the things which is now at present working and existence is that like they have acted upon the recommendations of India and South Africa, and they wanted the waiver of IP rights. That is one is that suspending IP rights and then giving some concessions regarding the IP rights is one side. The other side is the suspending the IP rights. The IP rights cannot be enforced, should not be enforced. That is what India and South Africa has made a demand, and then also negotiating with other countries. It's been supported by more than 100 countries, especially all the developing and least developed countries. There are certain resistance, but the waiving TRIPS, nothing to do with increased protection. See, you may waive certain provisions of TRIPS. Even we can debunk the TRIPS, but that alone, as I mentioned, that alone may not be the cause. So WTO will have to involve apart from TRIPS, and so many other aspects will have to be addressed regarding the vaccine protection, accessibility, affordability, and then also developing a strong IP policy, and then the other trade challenges. What are those trade challenges? The trade challenge, import, export, licenses, etc. And then also facilitate tech transfers. For example, India wanted to manufacture certain vaccines, but we may not have the technology, but we should get the tech transfer, technology from other countries into India, because we have the mass manufacturing facilities, but may not be having the technology and things like that. Technology in producing, technology in testing, and other things. So the tech transfer is very, very important thing. And WTO see to that, no, that has been available wherever it could be. The other aspect is that there should not be any border restrictions, undue border restrictions. And then the free flow of material, substance, and information will have to be available between the borders. Now we have the walls between the countries, and the walls will have to be knocked off, and then things like that. And finance. See, I may not have the finance. There have to be a corpus developed by developed countries. And then also, there are so many issues. So the issue here is that does not provide the solution of it. Next slide. Next slide, please. And the other aspect which we have been facing is that the vaccine nationalization, nationalism, that is meant, no, we know that. The US has already booked 2 billion vaccine, the shots for their own people there. And imagine they have invested $2 billion with the vaccine companies and things like that. So the question is that selfish, that only I need to protect my own citizen. Wonderful. It is a primary object. I know every country will have to, the primary object to safeguard the health safety of that country. But nevertheless, that should not be a barrier to block accessible availability of the vaccine to the other countries. That's important. For example, if AstraZeneca, I mean, it's been blocked by the European countries, then what happened to the other rest of the world? And if Moderna, Johnson, Pfizer is blocked by US, that guys, you have to manufacture and then you have to give to me only, then do them. But tell me, then what will happen? They have to be an equitable balance. Yes, protect the national health issues and all the other things, but at the same time, we have to think globally, and that is most important. This is the developing process, because the hoarding is a very important thing. And then it's not that, no, when there's a pandemic of a limited extent, you try to hold the vaccine for 5 years, 3 years. That's not acceptable. That's not fair. And that's what the intellectual property rights of the vaccine manufacturers are eternal. So the monopolies, the cartels, and then also you create a sort of fortress around a particular product or a vaccine. These are all some of the issues we have to address it and try to knock it off. Next slide, please. So the waiver provisions of WTO, it's very, very important thing. But this is it's a temporary provision. It has come for 1 year and now under negotiation. And there are certain aspects we need to see to that, how we can have permanency of such provisions in case of pandemics. And then, no, it is not short term. I'm addressing COVID-19 vaccine and that's all. Probably COVID-19 would disappear in a year or two. We do not know, but it could. The day has got an end, or to be. At the same time, it's not that every time we face this sort of problems, we have to negotiate again and again. Because the critical issue is the time. The negotiations, collective decisions take time. It takes a year, 2, maybe more than that. But the pandemic cannot wait. No, our lives is important. There have to be an emergency, quick action. Time is so essential, and that's the thing like that. So yes, it's a very, very difficult to bring in every country to agree upon certain things. But at the same time, they have to be an ad interim, a quick measure. And this is a quick measure. But what we need to target is the long-term measure. And that's an important thing. So the waiver of certain provisions of TRIPS has been acknowledged. But these are very, very important, the provisions. And TRIPS itself has got what you call adequate the protection there itself. For example, we have Article 1, which confers the right to the title holder. There are exceptions to that. Article 7, Article 8, Article 27 was very, very important. Even TRIPS Article 30, 31. 31, yes. And then also very important article, TRIPS Article 31 and Article 66 to 66 and 67. These are all important, the provisions of TRIPS. There are adequate safeguard to protect the public interest. And then also the health security, we call. That is there. But how it ought to be taken up, the countries have flexibility in that. They have a flexibility in that. And so the countries will have to make a decision. And then also sometimes it might be challenged. And that's why the WHO provision, it says that when the country takes anything like that, that should not be challenged. In my last slide, I don't want to go to the last slide. There is a provision where that WTO has made the provision that the countries should not challenge if another country takes some steps. It could not be go into the dispute settlement forum of WTO and challenge certain provisions of India in the things. So that waiver has been given. That's very good.
Calab, yes. Can I interfere here on your item number 5, where
yes.
Where United States and Switzerland has already taken up this matter on after the Novartis issue when when Section 3D in India was it could not be challenged at the WTO dispute settlement body, and now there is a on this particular Article 23 subclause 1B and 1C of the agreement establishing WTO. Now there is a moratorium under Article 64.2 of the TRIPS agreement.
Yes.
So the issues relating to the IPR cannot be, invoked under the non-violation clause, which these two countries have put a proposal in the WTO, which is also under the work program for discussion in next WTO ministerial conference. So there is a moratorium. They want an extension, of that moratorium under Article 64.2.
Exactly. They wanted the moratorium, and of course, the rule-making powers of the state. And then also, even if there is anybody who's made it, that should not be unnecessarily interfered and undue during this extraordinary condition. That is the thing. And the Swiss proposal is a wonderful proposal because, of course, Section 3D is not a only issue. Section 3D is for evergreening. It is for evergreening. And then the things. But what happened to the new drugs, new antiviral drugs, and what happened to the new vaccines, and what happened to the biomedical devices, and what happened to the preventive measures? Like I need to have something very innovative kit or other things. So many aspects and the things. So we need to have the moratorium for all aspects of this pandemic. It is not only just one aspect, but all other things. But the waiver, the WHO waiver is excellent, but it's temporary. We need to have this waiver to be permanent. Permanent in the sense that whenever there's a pandemic, locally or globally, see, whatever it is, wherever there is the widespread health issue, it can be selectively certain countries, certain region, or globally like COVID-19 thing, then it ought to be provided automatically. That's what our demand is. Things like every time I can't go on negotiation because, as I said, the negotiation takes time, and time is so critical. Other thing, we can't allow people to die. So can we go to the next slide, please? Tanpat, we can talk about this for days and days.
Yeah, I know.
But you are given a very limited time. So I just,
can
you go? Yeah, this is the in one shot that it's the patent right or the IP rights versus the patient's rights. And then we need to have, of course, there's enough flexibility as I mentioned it, but the objective is to have the balance right or the obligations or mutual advantage of producers and users of it. That is the critical one sentence, the objective for the patent or the IP rights versus the patient right. Next slide. Yeah, here, as I mentioned it, there are the issues, but important, the headline which I mentioned that there have to be discoveries. See, unfortunately, there's no antiviral drug for COVID-19. And there are so much of efforts. If there is a drug which can even eliminate 10% of the viral load in the body, that would be excellent because that will prolong the life, and then that will safeguard the damage created by the virus on the body. So discovery, and it ought to be developed, affordability, accessibility, and time. These are the 5 aspects, the critical aspects, which TRIPS alone cannot do that, but there are certain safeguards, but it ought to be taken by WTO. Next slide.
Gabriel, can I just raise one issue here on compulsory licensing? Compulsory licensing, Section 92 of the Indian Patent Act, though it allows, but the limitation is that only if there is a patent in India. Unless the patentee has a application or a patent has been granted in India, the government of India cannot invoke Section 92.
Yeah, definitely, sir. It's because a patent act is only managing the Indian patents. And the thing, it's an Indian Patent Act, so it's India. The territorial limits are prescribed. Even Section 1 of the Patent Act is applicable within the territory.
So therefore, the waiver under the TRIPS become important here because Pfizer may choose not to get a patent in India, and therefore no compulsory licensing and therefore no availability. So therefore, either since they don't patent in India, so we can definitely manufacture it in India, even without compulsory licensing.
No, but excellent. You're right. Of course, it is only 92 and 92A. It is for the emergency provisions and other things. But the issue here it is only relating to the Indian patent. 92A permits you to sell it outside. export, etc., and all the other things.
That is particularly with relation to para 4 and 5 of the Doha Declaration.
So what happened, 92 is such a critical aspect. And based on Doha Declaration and 2001 November, we have resolved that the country should have the option for emergency to waive off the right of the local patent. But the issue is that, forget about the Indian patent, but can the vaccine be manufactured without technology?
That is the major issue.
Yeah, and also can the vaccine be tested? I mean, we mean to say, can you say that I have a vaccine for only Indians, but not for others? Now we have to address that the vaccine should be given to the humanity everywhere. And India, we have given vaccine to about 6-7 countries and things like that. So Indian patent is a first hurdle. See, I'm a patent attorney. I'm a patent, but anyhow, nevertheless, when balancing, when the public interest versus the private rights, in this context, I support the private rights, public rights. And then my hearts go with those things. Here it is, when we have the Indian patent, you have the waiver. That's what Indian Patent Act can do. They cannot extend. It's called ultra-virus. It can't go beyond that one, other things. But hell with that. As you said, I don't want an Indian patent, but still I'll see that India cannot manufacture a vaccine, or accessibility of the vaccine can be prevented. And then, no, US can come out and say that vaccines should not be exported beyond the borders of US. They have the border regulations. And in that case, what to do? That's the reason we have to break that. But 92 is important because people will try to get a patent, something like that. That way we have that exception, that things. Let's go to the next slide. Next slide, please. And of course, we have discussed the developing countries, least developing countries. As I mentioned, that the TRIPS has already addressed certain issues, and how the country is going to interpret and take it forward is most important. For example, we are not made so far any rules or any act or anything which is on a war footing in order to see to that, no, the things are available. The thing it is, we are making all efforts, the budgetary provisions, many other things, but where there is a statutory provision that there is a need and requirement for the companies, the global community, as well as the Indians, to address and start taking it forward. At present, there's nothing. So next slide. Next slide, please. Yeah, this is the Indian things which Dhanpat has mentioned it. And then I don't want to dwell on it. But what happened, this is not alone. We have to now come out with certain extra things. People who are applied for compulsory license will have to be immediately granted. I think that that effort, there are certain applications pending before the patent office, and that has not been touched upon. And now there have to be government push that wherever people who have applied for any product for under 92, even for export of the product under 92A, it ought to be acted upon and quickly given permission. Because I do not know why this hesitation. Do we fear that others will object for it and things like that? But if we have to take certain steps, this is a conducive climate, wherein which we have to make that grant compulsory licenses for these guys to manufacture, who got the capability and capacity to do that, so that it becomes a tradition in course of time. And I think that that one extra effort, I have seen that it's not there. And of course, this is Indian side. Next.
I think NATCO took the lead for applying for the compulsory licensing, and then immediately it was granted the voluntary license.
By
NRDC.
Yeah, NATCO has applied it, the things, and it's under consideration. And there are one or two other applications also pending. So they have to simply make an ordinance or something else in order to say that, guys, whenever you apply it, if they are related to the COVID-19, you have a free to go on manufacture.
Just one more line of query. Can you just say something on section 47 versus 92, because section 47 is an inbuilt condition.
Yes. No, sir, section 47 for the government, and then section 47, 1, 2, and 4.
Yes.
This subsections gives you, it is like an exemption to patent rights. Like I have a patent right, and these are the exceptions to the patent right. Section 47 for exceptions to the patent rights. In that, the government got a free hand. It has got a free hand to manufacture in a product or a process and all the other things. And they do have it, but it is an exception to the patent right. Suppose, as you said, if there's no patent at all, but the Patent Act cannot address where there's no Indian patent, other thing. So section 47 is important, and it's a very powerful right given to the government.
Yeah, because you don't even need to invoke section 92 or 100.
No. Yes. They have to simply declare.
Yes.
This patent we're going to manufacture, and then also it will be supplied through our own channels and things like that, and also extended to the government agencies.
That's right.
And all the things. So it's a very important, powerful right given to the government. And any moment they can come and invoke section 47 exception. That can be there. And then only what we need to think about is waiver of certain benefits we're getting it. Certain licenses we are getting it. That's not our target. We need to see to that now. The campaign is to waive the IP rights. That IP rights as a whole will have to be, except one or two other rights like sound recording. We are not bothered about it. But here, the initiative India, South Africa made, supported by 100 plus countries, was that the IP rights will have to be waived during the pandemic. This waiver should not be temporary only for this. And then tomorrow some other pandemic will come, some other selective issues will come. Then we have to take a battle for another thing. There have to be some sort of permanency. This provision should have some permanency so that the international community need not face again and again and go for the waiver. There have to be. So, and the state should have the powers to declare along with W2 other things. For example, I have a huge health issue in India or the neighboring countries, India, Bangladesh, and Pakistan. And these countries can oppose W2 and get the waiver of IP rights and the things. This is that we have the target. But what happened, as regards of COVID-19, fortunate the US, Russia, and China is supporting us because they have been very badly beaten. When the first pandemic was there, US have got more deaths. So they realized that. And as a result, they have, okay, fine, the waiver of IP rights, but the European countries are not in favor of it. And the thing that the Europe, they wanted a short-term or a medium-term efforts, a concerted effort, but they don't want that sort of total waiver.
I don't know what would be the stand of Germany, because so far Germany has not agreed to.
So the European Union is a collective decision making. The individual one or two countries are having
the European Parliament, they have endorsed in principle.
Yeah, but the Germany is also tagging along. We will think about the short-term and medium-term strategies, but total waiving or the IP rights, it ought to be considered case-to-case basis and selectively. That is an issue. Why can't we tag along with the international community? And that is one of the things. But probably it can be taken care of. It can mellow down. It needs the discussion, the bilateral discussions. How Prime Minister, Honorable Prime Minister Modi visited USA and then flagged certain issues of the pandemic. And it thought to be taken wise wherever there is a big resistance to that extent to have the uniformity, a homogeneity in terms of this issue. And then
Jaishankar also took a lot of initiative during those the second wave time, visiting various countries for diplomatic discussion.
It is most important. And so, and then this is what my final comments and the thoughts is, because as I said, we can keep talking. The other speakers, others are there. So we need to have, this is the time wherein which we need to have some sort of the continuity and permanency in the things. It is not the first time the world going to face this kind of pandemic. We can face pandemic or local health issues, and it ought to be addressed in a sort of, a permanent solution. We need to think about it. And the second thing is that it can be done only by WHO in coordination with World Health Organization, other related organizations. Second point. The third point is that it is not only accessibility of the drug, but also a gambit of other issues, such as opening borders, tech transfers, finance, so many other aspects will have to, but it is not only addressed to the vaccine, but all the related products and substances, and then also technology, methodology, processes will have to be thought about it. That is the most important aspect of it. With this, I conclude. I don't want to take it. I have a large number of slides, but
thanks a lot.
I have not, and then I'm available. Any
for question answer.
Question. I'm here. Sir.
All right. Thank you very much. Thank you for a wonderful deliberation and your thought-provoking ideas, which you have discussed and spoken so well. Now, I invite our next speaker, Mr. Sudarshan Bansal, who is a senior partner in United IPR, and we have been benefiting from his good knowledge and experience for a very long time in GIPC. So I welcome him and request Sudarshanji to please start his talk.
Hello, Dr. Agrawal,
Yes,
and Mr. Gabriel, my good friends, and Gabriel is a professional colleague as well, and welcome to everybody else. I would like to just share my views on this very important topic. There is no doubt that the pandemic has affected all of us in some way or the other, directly, and directly it has affected us. We have all suffered in some way or the other. We've all lost dear ones, and we all looked for answers to find a solution to this problem. In my understanding, the solution, mere emotions and mere wishful thinking is not the test, and nor will it get us anywhere. What we require is a complex legal judicial structure that can balance various rights, and after balancing those various rights, a solution has to be found. Mere going to WTO and speaking on the Doha conventions, on trips, etc., we can go on and all, as my good friend Mr. Gabriel, and a very learned attorney, has already pointed that out. But in my limited thinking on the subject, in my limited knowledge of the subject, there are many other ways out, simpler ways out that can be done. A complex structure, and we have to find an answer within ourselves itself for immediate relief, rather than in emergencies going overseas and trying to negotiate. That could be very tedious, as we are ourselves have noticed. I would address this issue from the IP law perspective, the kind of laws that I deal with, and I think I would be in a better position to answer it from that perspective. The subject is wide, as my friend Mr. Gabriel has pointed out. Mr. Gabriel, I can just go for a few hours. Mr. Gabriel can go for days together. Anyway, now there are two major statutes that would, I think, would need to be addressed or to be noticed to make vaccines available or any other medicine, drugs available in cases of national emergencies. Number one, and the principal statute, is the Patent Act, and to some extent the Trademarks Act. But I will deal with it from a Patent Act perspective. Now, under the Patents Act, there are three provisions which directly come into play. And my good friend, Dr. Agrawal, has also pointed out to Section 84 that deals with compulsory licensing. But compulsory licensing has its own drawbacks from this perspective, that it can only be in respect of a granted patent, and number two, for 3 years, after 3 years thereafter. And then a number of incidences come into play, pricing, availability of the public. But the starting point is that of a patent, of filing for a patent. And Section 100 that gives the government of India emergency powers to deal with it is also when an application has been filed for. So once an application has been filed for under Section 100, has been filed for the patent, then Section 100 can come into play, and the government of India can enter into the picture and acquire it and manufacture and make it available to the large let us say to India at large, and also to export it to overseas countries, Section 47, etc., etc. But the moot issue is, can the government of India or any international treaty force a right holder or an alleged right holder to at least file for a patent? There are many companies, including in outside the pharma industries, that have never filed for a patent and yet enjoy monopoly rights. For example, the Coca-Cola, it has never filed for a patent. It just has a trade secret that it protects. An IP waiver, as my learned friend Mr. Gabriel has pointed out, no doubt. But an IP waiver has to start from where? Even if the IP waiver has been made under the international obligations by the government of India, that no patents will apply, nothing will apply, no common law principles can apply. Can it be the case that if a medicine that is, if a vaccine or a pharma or a drugs or whatever is not available, the technology is not available in India, can the government per se go and acquire it and say that we have nothing to do with it, we just need the medicine, we don't do the research, we don't do the development, the technology is with a corporation that is overseas? Can it just go and do it? Or can it be said that the corporation that is overseas, it licenses to an Indian manufacturer? We have seen it in the Serum Institute, in the Serum case, it came under a license. As far as I know, I'm subject to correction, a few of these vaccines that have been on emergency uses and trials, Mr. Gabriel and the others would correct me. Has it been the case that they've even filed for it, or they're just doing it under the technology transfers, under the common law and contractual principles? I have done some research on this subject, and my limited research, subject to correction, that these companies have not filed for it also in India, and not filed. And let us assume that they have not filed it. Let us go on the assumption that they have not filed it. Can the government of India just acquire it just on the basis of a license granted to an Indian manufacturer? I think this issue is of critical importance. Neither the press nor the media ever addressed this issue and pressurized the government of India. And if the government of India was given these powers as a parente patri that protects the citizen, as a father for the nation as a whole, then if the government was to exercise this emergency power, would the foreign or the overseas farmer who had the technology, would they actually bring it into India? And what if they just raise their hands and say that we will not bring this technology into India? A large chunk of our population would have been left without these vaccines. I think this is an issue.
I think certain issues of this nature were discussed in the WHO by taking examples from the human rights regulations.
Okay, Dr. Agrawal, thank you very much for pointing this out. And when I was going through the excellent debate, the excellent, food for thought that has been shared by my learned friend, Mr. Gabriel, I did some research on this subject just in the last 5 minutes because I knew this issue would develop. No, let us see. There is an international treaty. There are international forums. India is a signatory to those forums. There is no doubt with that. Now, by virtue of being a signatory to those forums, are those treaties ipso facto applicable at par with domestic law? That a mandamus can be issued by the court of law, directing the government to follow or to perform a certain act, bypassing the parliament. And this international law itself is at par with domestic law. So just by having a WTO, WHO, and all these international authorities in the ground of emergency, it is my humble submission, per se, the Indian law as I understand it, does not ipso facto make the WTO, WHO, or whatever Doha conventions, etc., the whole lot of them to be ipso facto at par with domestic law. A classic decision on this case, a classic decision of the Honorable Supreme Court of India has come, which has taken care of the so-called doctrine of dualism, of domestic law versus international laws, and how far an international law can be applicable to India bypassing the municipal laws. And a decision that was pronounced by Justice Krishna Iyer, whom we all know has been a great jurist, in the Jolly George Verghese versus the Bank of Cochin case. And it has also been, to a large extent, an excellent debate an excellent debate took place even before the Bombay High Court, which has returned its judgment, which has gone into a large aspect of these issues. In the case of Karan Dilip Nevatia versus Union of India and others, a lot of law has been discussed on this. But in nutshell, for the purposes of this debate, for the purpose of this discussion, in nutshell, the law is that the international law per se does not apply to India unless it is found through parliamentary legislation. International law can be used as a tool for interpretation of the Indian statute, to address gray areas or to give expansive meanings, but per se they are not at par with the domestic law, par with the parliamentary law. So if the parliament, in its wisdom, if let us say the international forum, the WTO, etc., has laid down 10 points, 1, 2, 3, 4, 5, 6, and the Indian Parliament, in its wisdom, just decides to take 4 of those points and make it into a statute. The remaining 6 points per se cannot be imported into the Indian statute, unless they can be used to interpret it, but ipso facto not applicable. So I think in the pandemic situation that we have, this issues whether Section 100 or whether the Indian government could have, by way of an ordinance, as Mr. Gabriel had pointed out, or through a legislation, amended Section 84 of the Act or the Patents Act, or Section 100 of the Patent Act, to just ipso facto make even any technology that enters into India, even by way of a license, it has entered the Indian borders, that the government could acquire that technology, multiply it by, put it to work in different factories and different farmers, and multiply, and thereafter make dispensation of the vaccine to the Indian population as a whole. I think this is the moot question that needs to be answered. And unfortunately, the Indian legal structure or the Indian parliament structure that we have, or the Indian, has not, so far, this issue, I understand, is, I would not say out of bounds, but this needs to be tested. That when, and how far will the right holders agree? You have to give some leverage to the right holders or the inventors. I would not say the right holders, the inventors. After all, they have the inventor has the technology. An incentive has to be given to the inventor so that he brings it.
So, Mr. Sudarshan, your point is, like, Sputnik has given license to Dr. Reddy. So you mean to say, even if Sputnik doesn't apply for a patent in India, Section 80, whether Section 100 or 92 can be invoked? This is your research.
In my limited understanding, that even if a license has been given to an Indian company, and the technology has entered the Indian borders, and a license and a patent has not been applied for at all, then under the Patents Act or under the IP laws, under the codified IP laws, under the parliamentary IP laws, trade secrets is yet governed by common law principles. There is no statute that addresses it. So under the existing statutes by Parliament, under the Patents Act at least, the Government of India has got no authority. Under Section 100, Section 94, 47, 84, and some other of the beneficial provisions that by learned friend and a distinguished colleague, Mr. Gabriel, has pointed out. Even then, the Government of India is powerless to do it. Now, how can we mold our legal judicial structure to take this into account? And can we just, the moment the technology has entered Indian borders, can the government just come and pick it up and make it and use it to dispense it to everybody? Either this debate during the pandemic should have been initiated and pressure would have been put, but the government is also under restrictions. It has own limitations, because then the right holders, the inventors would never have brought their technology into India. So what the government did, I think, was the right thing in this situation, that it encouraged its own laboratories to create it. So its own laboratory, the Bharat, yes,
Biotech.
Biotech.
So it self created a vaccine, and which the government thereafter, without claiming any rights in it, dispensed it to the large population of our country. I think that was a very good, that I think, to be outside the purview of these IP laws and the complexities, and to keep lawyers and academicians and the press people happy, and left them debating. That was a very good solution that had come forward. And not only for India, but even under Section 40, etc., even exported it to a large population outside our geographical limits.
But the pity of the thing is WHO is yet to recognize the Bharat Biotech vaccine.
Agreed, Dr. Agarwal. We have faced it. Even the UK government, as going by press, has raised such objections. Of course, they will have their own compulsions. After all, we are competing with them on the international stage. There are conflicting rights that are involved. I mean, there are pressure groups, there are interest groups that, that have set up claims. One product sold from India means one product not sold of theirs. And similarly, all these are there. The trade wars, the trade are there. An international mechanism, no doubt, is required, to address these issues. But even if those issues are addressed, the question is that how can it become part of the domestic law of India that we as normal citizens can enforce, actually in a court of law? For that, you need structures much more than just mere wishful thinking and just emotions. This is what the issue I'm trying to address.
Very good.
And under the Trademarks Act also, though Trademarks Act deals with origin of goods and etc., and not per se with the technology involved in those goods, not the engineering, but as a source of origin of the goods. Section 13 of the Trademarks Act has also, in some way, I would not say directly, but in some way has been or could have been invoked. I just read Section 13 of the Trademarks Act. Prohibition for registration of names of chemical elements or international non-proprietary names, and no word which is declared by the WHO and notified in the prescribed manner by the registrar from time to time as an international non-proprietary name, or which is deceptively similar to such name, will not be registered. So we could have had a register made. The WHO could have been pressurized into declaring many of these names as to be non-proprietary. And we noticed that there was a dispute that went up to the Honorable Supreme Court of India in a trademark dispute, where an injunction was diluted. But that was done by the Supreme Court and not by the Registrar of Trademarks, by exercising its jurisdiction under Section 13 of the Trademarks Act. So, sir, in a nutshell, what I wish to say is, my main say is that yes, vaccines must come in national emergencies, and the government has exercised a power under these provisions under the old Patents Act of 1911 in the 1960s, just by going when under the PL 480 scheme, a large chunk of wheat and other things was done, but the government did acquire some calcium producing, some calcium, bearing medicines, because at that time there was a pandemic that affected this. So that was required. So it is not that the government has not, that the government has not acted. But in the present case, the legal structure, the parliamentary structures and the international laws that we had, I think an ordinance or some pressure could have been put on the government to have addressed this issue of diluting section 84, not only to a patent, even to a pending patent application, exercising powers under Section 100 if a patent had been filed for, and if no patent has been filed for, if the technology comes into India, then the government of India could have been asked to acquire it and make it. Now, I don't think it's very easy for us to say it, but for government to exercise such powers, And what if the inventors had just said that we are not going to license it, we are not going to bring it, we will just take it away?
Thank you, Sudarshan.
Can that be forced? I mean, can WTO, WHO, etc., can force an inventor to bring his invention into the public domain without giving him some form of a protection and as a matter of right by a government that can be acquired? I think this would require a larger debate.
I think you have raised a very, very important issue. And as far as United States is concerned, we all have seen that many times they don't agree with the international law. They would first apply their national law and then they would refrain from giving recognition to the applicability of the international law in their territory. So similar thing is now important on the doctrine of dualism, which you have said rightly, and then also a new point which you have raised about applicability, invocation of Section 13 of the Trademark Act. So I think our subsequent speakers, they can take up and then
only one intervention regarding my learned colleague saying conflict between the domestic versus the international law. That has been settled by the Supreme Court, wherein which if there's a conflict, the domestic law would prevail. Other things. And the thing has been borrowed from the concepts from the judgments from the House of Lords in UK. That thing, even not only the conflict, but the power of the Queen, even to break international treaties and international law, they can go even against that. Not only just make them mute, but also even go against them. So that way, is thanks for pointing out this, Sudarshan. Thank you.
This is a debatable issue. So I think in the taxation law also now this matter came up for in the case of Cairn and Vodafone also. So it's a debatable issue whether and to what extent the international treaties will apply and to what extent the Indian tax law can.
That is the commercial aspect. Here is a health issue, national emergency.
Yeah, I understand. But then overall, this is a very crucial issue to be discussed and deliberated. Now, I request Mrs. Renu Bala, the managing associate of SSRANA and company, to present her views. Renu Bala.
Thank you very much, sir. I feel really honored and privileged to speak in front of a great audience and eminent speakers. So basically, I think Dr. Gabriel and Bansal sir has covered all the topics. So I'm just short of what to speak, but I had shared a slide. If you can just on the basics.
What's up?
Thanks a lot for sharing the slide. So I think next slide. Yeah, so I mean, it's just the basic TRIPS agreement. So what exactly the TRIPS agreement covers, basic principles of minimum standards to be adopted so that the members are left free to use appropriate method of implementing the provision of agreement within their system. What the TRIPS agreement lays down simply is the basic principle for maintaining balance between innovation and public welfare. And there are few articles which are in compliance with the domestic sections and rules. And it lays down minimum standards of protection to be provided by each member, domestic procedures and remedies for enforcement of IP rights, dispute settlement procedures, and general rule for reducing procedural difficulties in acquiring or maintaining IPR. So basically, the TRIPS is in coherence so that the IPR protection and the obligations and the responsibility go side by side in parallel. So it provides these basic principles and standards and some procedures, and it also gives flexibility to the WTO member countries so that they can adopt these procedures and basic principles in their own respective acts according to their country's practices. Next slide, please. So Dr. Gabriel had already touched on these, but just very briefly, what Article 7 is, it basically refers to a balance of rights and obligations by all the WTO members. So Article 7, it says that the promotion of technological innovation should be, to promote this innovation, keeping in view the mutual advantages of producers and the users of the technical knowledge, and it should be conducive to social and economic welfare. So basically its motive is to create a perfect balance to innovation, mutual advantages, and economic welfare. So the Article 8 gives flexibility to the members so that they can adopt measures necessary to protect public health and to protect the public interest. So Article 30 also provides exceptions to the exclusive rights conferred by a patent, such as use for R&D. So basically the R&D, they can all the members can use the patents and protected right for R&D. And Bollard provision gives use of they give relaxation to the infringement in case, and they can use the patented invention for development and submission for information regarding the regulatory approval. Article 31 gives grounds, terms, and conditions for compulsory licensing. It gives a condition, and the basic, basically all the WTO members can formulate their own terms and conditions and grounds on which they can grant compulsory licensing. Then there is Doha Declaration, which give flexibility to WTO members in determining conditions that constitute. So they can determine basically what are the condition, terms and grounds for declaring a emergency, and for deciding grounds and terms for granting the compulsory licensing. So basically, when it comes to vaccines, can you please move to next slide? Yeah, when it comes to vaccines, so basically there are many IP rights that are involved in the vaccine. So there is a copyright, there are trade secret, and there is a lot of clinical data in vivo and vitro studies. There are patents, there are trademarks and copyright. So basically the vaccines, when this term is associated with a lot of IPRs, and there are many challenges in these in the protection of IPRs, starting from their development, research to the launch in the market. So the various challenges of the vaccines include, please move to the next slide. Yeah, so basically R&D requires a lot of funding, which normally the governments do like in US. So there is a lot of funding in this R&D activity and of vaccines. So it's a very costly procedure. And secondly, the vaccines development is a very tedious process. Thousands of molecules have to be tested before coming to a particular vaccine. Then the protection of IPRs. So there are a wide a number of IPRs which have to be protected, and which is a very long it takes a long time for a applicant to develop and to get protection for IPR. So definitely he has to be provided a proper remuneration to develop and to putting so much effort in developing vaccines. So then there is a regulatory approval that is required, which takes a lot of time, which takes a lot of effort, animal studies in vivo, in vitro, and there is a lot of clinical data required to get that regulatory approval, and that too takes a long time. Then there are challenges in marketing and distribution of various drugs. various IP licensing, collaboration. So these all challenges are there when we talk about vaccines. Okay, so there are a lot of challenges when we talk about vaccines. So so basically, what is there in the TRIPS agreement, which is conducive to and which gives relaxation to the these procedures and to short down the timing required to bring down this time and the procedures. So Article 62 of the TRIPS agreement says that the members to comply with reasonable procedures and formalities for maintenance of and for acquiring and maintenance of IP right, and it should not be very costly or protracted. So various countries have been adopted various measures to reduce these timelines. For example, in Brazilian National Institute of Industrial Property, they prioritize examination of the application related to innovations that can be used to fight COVID-19 from 7th April 20 to June 21. So USPTO, So USPTO and trademark offices, it prioritized a patent application examination pilot program, which expedites the technology relating to COVID-19 vaccines. And then there is a deferred fee for provisional patent application till you file a non-provisional application. And then they also the USPTO also provide a collaboration database for exchange of information about inventions designated to combat COVID-19. So even after they file a provisional application in USPTO, then there is a COVID-19 database which gives access to the people for developing, for taking forward that provisional, that information to develop for COVID-19 related vaccines or the related instruments. Indian Patent Office also also reduced paper correspondence. They extended deadlines and switched to oral proceeding in case of hearing, or for physical they postponed or they held it virtually. So likely this information is provided on a COVID-19 policy tracker in WIPO. So there the different country where the WIPO tracks these remedies or measures taken by the various IP offices throughout the world. So then there is another TRIPS provision which was first introduced in 2003 by means of a waiver decision and now permanently incorporated in Article 31 base of the TRIPS agreement. So basically what this says that there was a Article 31F that if a compulsory license is issued, then that particular license is used to create and develop and manufacture the vaccine to be used in the domestic market and not for exporting. So basically it was this Article 31 base of the amended TRIPS agreement. It says that Article 31F shall not apply to the compulsory licenses for the purpose of production of a pharmaceutical product and its export to the least developed country members or members having insufficient or no manufacturing capabilities in pharmaceutical sector for products in question. So basically this was developed basically for the least developed countries, or in case of for few countries in case of emergency situations in the country. So and so there because of that, I think there are list of so although these compulsory licenses were not that much, but few compulsory licenses I've listed here. What exactly in 2020, late 2020, the Hungarian government granted a compulsory license to remdesivir to support a domestic manufacture. Israel issued a compulsory license and turned to generic alternative of lopinavir or ritonavir, AbbVie's Kaletra from India. Later, AbbVie also announced a global non-enforcement of patent on lopinavir and ritonavir for all indication, including HIV and coronavirus. Russian government also issued a compulsory license to pharmaceutics to produce generic version of remdesivir, because that was a very demanded medication in the times of COVID pandemic. So it was a very good step taken, and these compulsory licenses.
Bala, we need to understand what are the local patent laws in Hungary, Israel, and Russia, because in India we could have also done, but because Indian patent law provides that unless there is a patent applied for or granted in India, we cannot invoke. So maybe we'll have to look at the provisions of the compulsory licensing in those respective countries, because maybe because as far as I know, that Pfizer and other this they have even AstraZeneca, they have not applied for patent in those countries, but then that is a issue about the local law in those countries.
Right, sir. So basically, sir, I think that the compulsory license are they should be left to the domestic, the country-wise, like a decision from that particular country, because they only would understand the situation and pandemic at the situation, because at the end of the time, at the end of this, we need to understand that the life of a person or a life of a particular country's resident is very important, and there are remuneration. So I'm in agreement with Dr. Bansal, but the thing is, like, with the remuneration, proper remuneration should be given, but at the same time, the life, there should be some decision to be taken when there is a question of life. So I think the PPT has been unshared. I cannot see PPT.
One second.
Right. So talking about the WIPO TRIPS waiver. So as everyone know that this waiver is directed to address few problems. That is a vaccine inequality. So inequality in the distribution, production, and pricing of COVID-19 vaccine is a first major problem, and insufficiency of existing waiver provision in fighting COVID-19 pandemic is a major problem area. So this is very evident that there are confirmed. So how many doses were available to the people of that country? So this is a graph which actually tells us that the low-income countries were in a very, they were not accessible to the vaccines, which were very essential in the COVID-19 pandemic. So so this graph tells the confirmed number of doses purchased by country income level classification. So we can very clearly see that a high income country people, they can easily access vaccines as compared to the people of low income country. So that is why the certain waivers and certain compulsory license are essential when we talk about the human life and equity. So if this waiver would be, this waiver can benefit India in the following ways: that more vaccine will aid the country to control the pandemic, and it will be a boost to the India pharma industry. And now at present, there are so many active compounds that are involved in current R&D, and when they are granted or when they come to light, they will help fight COVID-19 in a better and effective way. So this can be possible only through a waiver, and this challenge can be addressed.
Bala, can I request you to end here, and we can take up some of your issues during the question answer after the
sure sir, sure sir. Thank you, sir.
So okay, thank you very much. You brought in certain very relevant issues as per the provisions of the TRIPS, and particularly the highlights on the invocation of compulsory license by Hungary, Israel, and Russia. This is very important aspect which you have brought in. I think this issue being so important, and you also mentioned about the the applicability under Article 31 Clause F, and as per Doha Declaration, this has already been amended in the TRIPS regulation through 31 BIS. So I think my hearty thanks to you. All the participants have greatly benefited from your deliberation. So now I request our next speaker, Dr. B.K. Sahu from NRDC, to make his presentation. Over to Dr. Sahu.
Thank you, Dr. Agrawal, for giving us the opportunity. And also, this initiative certainly make the difference to the society as a science technology policy analyst and also IP professional and technology transfer professional. I would like to submit some of our critical views and also the point we need to deliberate and discuss at this challenging time. And certainly I'll compliment GIPC for this initiative time to time, connecting all the stakeholders in the country and globally. And also we have an excellent team of experts from the Gabriel sir, Bansal sir now, and also Renu Balaji. But I would like to tell you and also apprise you the first point I wanted to discuss before you. We must have to revisit the Universal Declaration of Human Rights on the Article 27, that everyone has a right to protect and the intellectual property, whatever they have created. And at the same time, I'd like to just apprise you, because everyone knows that issue. And this COVID-19 pandemic has already victimized million people, overloaded with the national health system, and also that led a severe economic crisis. And at the same time, the issues today in the society is that politically the coronavirus outbreak challenged the multilateralism and its institution particularly, and brought nationalism back to the global agenda. And at the WHO has certainly there is a target and also target of conservative political leadership, and that spread the particularly the protectionism practice had been hampered to the export of medicinal product and supplies, and also related to this COVID-19 pandemic, many medicinal devices, particularly tracing, testing, and treating. So one side, we are going from Millennium Development Goal to Sustainable Development Goal. And I will just point out some of the article as already might have covered by my previous speaker, but I would like to point out that Article 66.2 of WTO TIPS very well talked about the technology transfer from the technology developed country to technology less developed country. And since we are talking about intellectual property, and as far as the technology transfer and intellectual property right, these are the two most important issues that need to deliberate, because whether we are protecting or not, and technology transfer is a different subject matter, and already Mr. Bansal has also touched upon. So point today is that how our multilateralism ecosystem of the ecosystem like WHO, WIPO, WTO playing an important role, and we must have to analyze the Costa Rica submission before WTO about the equitable benefit sharing and universal access of COVID-19 vaccine to all. At the same time, in 2020 there was a international cooperation to ensure global access to medicine, vaccine, and during the United Nations General Assembly that touch upon the two resolutions that rapidly scale up manufacturing and also equitably access. And still we do not know about the definition of equitable access and fair distribution to those countries who are not that much of in development of this COVID vaccine. So for that, a broad sharing of IP rights and know how to facilitate deep technology transfer, and that is very, very necessary today. And also I would like to urge you that the urgency to respond to the ongoing pandemic made it clear that broader collaboration and solidarity and an effective global health security system is face a global pandemic today. And one of the most serious problem what we are seeing is the situation that we have been facing in this last 2 years is the unequal availability of pharmaceutical and medicinal equipment to the people, and there is a need of more global innovation ecosystem to boost such kind of manufacturing process, because international system of innovation is required in connecting the dot in collaboration and cooperation, because now the nationalism plays a very important role, particularly in the vaccine supply, and that has been also put in place in practically. So I wanted to just subject to need to address how the COVID-19 has a unequal effect and also benefit generated by scientific progress, particularly that do not seem to benefit everyone, but certainly create a impact the society in mitigating the challenge of COVID-19. So today, what we wanted to have a policy, and that we have been discussing time to time also, the accessibility, availability, and adaptability, the 3A effect. Another, we need to adopt the 3P, public-private partnership. So we have been talking about that, but how we are implementing that is very important today in the changing paradigm of the ecosystem of innovation. And we must have to generalize and also originate a comprehensive strategy to ensure massive vaccination, because, and that has been also a process has been already started, put in place, and also there is a accessibility and affordability of technology, but how we are providing that technology to the least developing countries, those who are not manufacturing that kind of vaccine. So it is the need of the hour to understand as a policy, science policy analyst, particularly on the issues of trips and public health that is already put in place, and also the emergency and compulsory licensing, parallel import, all these are already put in place, and that has been already deliberated. But how actually we are going to implement in the country, and the vaccine nationalism became a, I think, global agenda, and the multilateralism has failed, particularly in mitigating such kind of challenge, and that need to be also discussed. At the same time, we need to discuss the access to affordability of the medical product that Gabriel said talked about, the diagnostic kits, personal protective equipment, ventilator, and the medicine of the patent. That treatment still required, and we must not confine to IPR, because intellectual property certainly keeps the benefit sharing, and we must have to recognize inventor, innovator, and creativity of the invention, but at the same time, that should be also societal benefit. And that, in that effect, my two humble submission is we must have to analyze accessibility, adaptability, and availability, and public-private partnership in this thing. Thank you, Dr. Agrawal, for giving me the opportunity to discuss, and certainly we'll discuss more and learn from each other, and how we can strengthen our national policy towards the mitigating the challenge of this pandemic, and also we can create a vibrant international system of innovation in mitigating the COVID-19. Thank you, all of you. God bless you. Jai Hind.
Thank you, Dr. Sahu. Thank you very much for a very precise and to the point deliberation on the issue. So now we have about 15 minutes time for question and answer. So one question that was put in the chat box was, I think, addressed to Mr. Sudarshan, and wherein it has been referred on the issue of this international laws, wherein the issue of Monsanto recently for the price where the government intervention was there for the royalty issue, and so whether similar action could have been taken in case of, so that is one question. I think we can discuss on that, and we can take up more questions from the floor. So Mr. Darshan, would you like to say something on that?
I would like to say something. See, whether we should have or whether something should have been done or not done. Now, this is to be or not to be. It's quite straightforward, simple to say that. But behind this to be or not to be, or should it or should not have been, again, I would say these are complex. Behind them, there are a lot of complex issues. A legal structure, a judicial legal structure is required for a government to do a particular thing or not do a particular thing. Now, the government can intervene. The government has, in many situations, has powers. In many situations, does not have any jurisdiction at all to do it. So, from a policy decision, of course, the government, as a citizen, I would say yes, the government should have done it. The government should have intervened on royalty issues. The government should have intervened on pricing issues. And I think to a large extent, the government who has, I mean, within the many constraints that the government does have, I think it cannot be said that it has not done it. Of course, licenses were, the government did facilitate licensing of the technology for the vaccines to be manufactured in the Serum Institute. The pricing had also been addressed to a large extent. The dispensation, the distribution, the various state quotas. So I think within in a very short time, in a pandemic like this, which perhaps not many of us had even foreseen. So I think, yes, the government should have done it, but yes, you need a legal structure within which it can be done. And if the legal structure was available, if my friends can ask me that this was the structure that was available, and yet the government has not done it, of course, that could be a cause of, a cause of action can arise on that.
Thank you, Mr. Sudarshan. Another point which I would like to mention to Dr. Sahu, he mentioned about Article 66.2. But I think 66.2 is confined to least developing economies. Yes. It's not open to all the economies. So Article 7 and 8 is much broader in its approach for the technology transfer and for the health related issue. So 66.2 is very, very limited to LDCs. It's not for all the countries. So therefore, the matter which has been taken by India and South Africa together, that is by invoking and necessitating the application of Article 7 and 8 of the treaties. So members, the house is open, so anybody can I think they can be unmuted. You just raise your hand, and or somebody can put their query through the chat box also. Or can I request Gabriel to say something more on this vaccine nationalism issue? Because Dr. Sahu also mentioned about it. So multilateralism versus unilateralism. I had presented one paper in WTO once on this multilateralism at crossroads.
So if I can just intervene, so just to take the question to Mr. Gabriel again, just to add for that in one go, he can answer that. So, and to Dr. Sahu as well. So nationalism, multinationalism, yes, no doubt. And we will like to hear my good friend and distinguished colleague, Mr. Gabriel's views, and of course, Dr. Sahu as well. But nationalism cannot be taken to the extent of a misplaced nationalism. So please, Mr. Gabriel, please keep this also in mind. Nationalism, yes, but it must not be misplaced or a boisterous nationalism, and to that extent that an inventor who's not in India and the technology is not in India should be so disheartened that he does not bring it at all. So please, I would be grateful if we could have your views, and of course, Dr. Sahu also on that. So.
Okay, Calab.
Calab sir, please unmute yourself.
Unmute. Yeah. Calab, you can unmute yourself. Dr. Calab. Calab, you have to unmute yourself.
So in the meantime, sir, can we have Dr. Sahu's views on it, sir?
Yes.
I'm muted.
Yeah, no, I think.
Sir, regarding the nationalism and internationalism, definitely the nationalism should reduce and could be the extremely low levels and limited, whereas the internationalism should increase, and that should grow. And in case of this, the global approach, that's important thing. And as regards the local laws and things like that, we have already mentioned that if there's a conflict, the domestic law would definitely prevail over the international treaties and international law. The other aspect, there are two other simple things which I wanted to flag it. One is the commitment to tech transfer. The most important thing at present, what we face is the technology, the things. And so there have to be a commitment, the global commitment, the global community will have to commit themselves. There have to be a tech transfer, wherever it is, in whichever form, it ought to be available in order to address this pandemic, all aspects of the pandemic, that should be there. And we need to work out some global thing on a war footing. Thing. This is an opportunity. See, there are trips, there are other things which have been, but people may not be sensitive for that. Other things are. So you have to bring them into the fold and see that they have to be, my humble suggestion, have to have a treaty for tech transfers, available tech, and then the research. For example, I may be able to, some component of research, if I'm able to get some basics from somebody else. So this will have to be a free flow of technology and information should be available, that we need to have some sort of treaty for that one. And then especially in terms of pandemic or national emergencies, it ought to be there and things like that. The second thing, which point I wanted to just share is, there have to be global finance, there have to be global funding. Global fund should be created. Why not? $500 billion. India may not be able to afford so much. We may be able to afford other things. I may be able to do many other things, but there have to be global funding should be available for all the people who want to deal with research, discoveries and research, and many other aspects of the things. Because what we are starving is a funding and also the technology, other things. And we need to have some sort of treaty or an agreement for just pooling your fund, which should be available and accessible to the parties. I mean, it can be checks and balances. It can't be just thrown, money cannot be thrown, it should be checked, but it should be available to those parties. And then for the global funding, like that of the carbon finger, we have the carbon printing, wherein which the environmental agreement, we says that if you're able to reduce the carbon footprint, then I'll get the benefit of it. Like that, some models are available. We can create a global fund. I mean, I may not even propose $1 trillion, but at least $500 billion will be easily available from the Western, the developed countries, in order to do research, discover, develop, and then also make accessible. And there is a flow of information from all aspects globally in order to make it. And then if such things are available, then no, we may be able to short circuit in of the long drawn process and other things. We may be able to find out some solution to this pandemic, such as an antiviral drug. It can be herbal based. It can be anything. And we are able to give it to the international community with this international effort. That is most important. And then also the global fund, which I'm proposing, can also compensate to the inventors, the patent holders, etc., other things like that. Because compensation is also, see, we don't ask everybody to do charity. And then at the same time, I'm not going to go and beg, give me technology with it. And they can also equitable compensation and things like that, the global fund can take care of even the compensation to the right holders and things like that. And these are some of the thoughts we need to, finally, we need to take bold steps. Like, why not? The government come up with an ordinance and say that that tech transfers, whatever other things should be, it should be available to everybody. And that it cannot be less localized to only some biotech and other things. And then it should be available for any other people who are capable of manufacturing the vaccine and other things. And then what happened to the regulatory approvals? Say they have to do something. At the same time, safety of the drug, safety of the vaccine is so important. But at the same time, they need to go and do long-term 5 years research. By the time the pandemic itself will be over. But so they have to, the approvals will have to be stable and steady, thorough, but at the same time, they have to work on war footing to grant approvals, all this thing. So it can't be taken as a normal drug approvals. It ought to have the special channels. And then we have to do that. Do the limited testing and things like that, and try it for it. As such, we are all tried. So I don't think that, see, we are all guinea pigs. Millions of citizens of the world have been all the guinea pigs of this one. I don't think that the vaccines have been tested and tried and proved to be excellent in all circumstances for all people. It is not so. So, but we need to find solution, not waiting for long term, short term, other thing. So thank you, sir. If anything, I will be able to answer.
I would just like to
Dr. Sahu?
compliment. Yeah, I'd like to just compliment and supplement Mr. Gabriel here. But we need to limit this unilateralism, because especially by the richest countries which have the greater capacity to obtain a vaccine, there is a manifold of advance purchase agreement. And then also I would like to apprise in this August forum that according to WHO Director General, unquote, it is crucial to prevent a vaccine nationalism, which has been underway since the beginning of the pandemic. And the multiplication of the advance purchase agreement between pharmaceutical companies that are producing few approved vaccine. I mean, that was in the second stage of the trial, and a few countries is the new and most threatening from the vaccine nationalism. That is on quote I would like to share with you. And this is came from a statement of the WHO Director General. So it is the high time to understand, because the advance purchase agreement among the first pharmaceutical companies and some of the developed countries are multiplying day by day. So there is need to define the terminology equitable benefit sharing and universal access of vaccine particularly, and that was my submission in this forum. Thank you. Thank you.
I think the matter needs to be taken up very strongly in the forthcoming WTO ministerial conference, because this is the opportunity, because otherwise there may be some lobbying from certain pharma companies who have their vested interest. But then similar to Doha Declaration in 2001, I think on this national health emergency issue on the COVID, where the entire world is getting affected, I think the opportunity should not be lost at the forthcoming Geneva Ministerial Conference of WTO, because that is the final decision-taking authority, and all the member countries, because what Dr. Sahu has mentioned and what Dr. Gabriel has also mentioned, and as a whole, I think that this is a critical issue, not only for this COVID situation, similar to this may come in future also, because the way the environmental problems are coming up, so any kind of new disease may come. So for that also, for a long-term solution, and as Mr. Gabriel also mentioned that there should not be any temporary waiver, there should be a permanent waiver, because initially both South Africa and India had proposed that during the negotiation at the TRIPS Council that, okay, let's go for a 3 years waiver. But I think the idea of 3 years limited waiver, because nobody knows how long this may prevail. So, every now and then we are looking for some new variants. So there may be some new variant affecting the children also. So there's a need for a permanent waiver for the patent. And also I agree with his idea about the global funding. But yes, this should be a critical issue, and we need a long debate on the issue about the methodologies and how this can be built up. But the idea is good. So anybody else? Sasank Moria, my dear friend, if he wants to say something. Dr. Moria.
Thank you, Dhanpatji. Am I audible?
Yes, yes, very much. Yes, sir.
Well, let me first admit that I really, really enjoy the discussions in your GIPC. It has been an excellent discussion. And frankly, I have not been looking into the laws and provisions of TRIPS and Indian Patent Act. So it becomes a great refresher course also for me to remember all those clauses which I used to read when we were negotiating Dunkel draft, and going in interministerial meetings. I was going in interministerial meetings in those days. Having said that, being from the research organization, obviously, my views become slightly different, and which is why I raised the question of Brazil.
There is some communication problem due to technology.
Okay, the reporting stuff. South Africa also brought in the Public Research IP Act in 2008, when Department of Biotechnology also piloted the public funded intellectual property bill for India. But then that could not go anywhere. In short, several difficulties are there of multilateralism. There is another issue of vaccine skepticism. Leave apart vaccine nationalism. Vaccine skepticism. So the issue of, proper planning and research is must. At the end of the day, I remember, let me conclude by saying, I'm remembering the initial remark of Dhanpatji that 800 crore people have already been vaccinated. So the question is, because of difficulties of negotiation, probably people may keep on getting vaccinated. And we need to really do a long-term thinking, as was said by Mr. Gabriel, timing, target, he was saying. I mean, this is all required, leading the poor nation, 100 nations, IPR waiver, everything is a must. International politics, it's necessary. But at the same time, the basic building blocks on the ground. For that also, we need not long-term, but very long-term thinking. I think that is enough for the time being. Am I through? I'm through, sir. Dhanpatji, I'm through.
You are mute. You are mute.
I am not mute.
No.
Dhanpatji is mute. Dhanpatji is mute.
Sorry. All right. So thank you, Dr. Moria, for your very, expert remarks, because I know that you had been involved with the WTO Dunkel draft and a lot of this discussion. But then, of course, your expertise is more on the plant varieties and the Pharmacide Act, and as a ICR Additional Director General. But yes, you had a lot of contributions in the IP law in the country, in their drafting. So
I remember Mr. Gabriel's support on Basmati patent work in the challenge in the US.
Yeah. So friends, we have greatly benefited in today's this first session, which was primarily on the universal access to the vaccines and medicines, about their affordability and accessibility, and particularly under the provisions of the TRIPS. And all the speakers, they have dealt very particularly and very nicely. So I'm thankful on behalf of the GIPC to all the speakers, Mr. Gabriel, Mr. Sudarshan, Mrs. Renu, Bala, and to Dr. Sahu. Dr. Sahu, I think, is not visible, but in any way, all the four speakers have taken part, and we are obliged and grateful to all of them. And I think there will be no more questions on the issue. We can, I think, can we conclude this session if everybody agrees? So we can conclude. Okay. Thank you. Okay. So the same link will be available for those who will be joining. So next session will start at 2 o'clock. At 2. So now we go for a lunch break. Well, of course, in GIPC, we really rejoice the lunch together. But and now, since we are through this technology, yes, but we look for the physical meet very soon, sometime in February or March, as per the situation of the COVID. And so maybe soon we will meet together physically also under the banner of GIPC. But in the meanwhile, I announce the conclusion of this session, and thank you all very much. And we meet again at 2 o'clock. Thank you.
Thank you so much.
Namaskar.